Good evening to everybody. Thank you to WIBN for giving me the opportunity to present tonight. Firstly, I really wanted to say a little bit about myself. I'm Susie K, and my business is Your HR Partner, and we are HR and employment law consultants. I'm a chartered fellow of the Chartered Institute of Personnel and Development, and I've worked in the field for over 20 years. Initially, I started in the corporate world, held senior HR management roles in the city for over 10 years, and established Your HR Partner in 2010. What do? We advise employers on managing their people issues in line with employment law, and that's really across all sectors. So we have clients such as retailers and hotels, through to accountancy firms and charities. And I've been delighted to be a member of WIBN since 2016. So just a little bit more detail about what we do. Quite a wide range of services. We'll draft employment contracts and staff handbooks, give advice on employment law and HR, give guidance on disciplinaries and dismissals, and also advise on staff appraisals and running 360-degree feedback. And sadly, recently we have given a lot of advice on restructuring and redundancies. So what am I going to cover today? It's quite a broad agenda. I'm just going to really touch on the employment law aspects of some of these topics. And obviously, if you do employ people or you're planning to, feel free to follow up really at any stage. So we'll start by talking about employers, the difference between employees, workers and contractors. I'll touch on contracts and IR35, but Nicola did touch on that earlier, so I'll try not to duplicate what she's already told you. We'll talk about the right to work in the UK, which is particularly important, obviously changes following Brexit. Then I'll touch on employee rights and how to manage things like misconduct and poor performance. And then we'll move on to some examples of cases of social media and the workplace. And then we'll end up talking a little bit about the furlough scheme and redundancies. And if you do have any questions, feel free to put them into the chat box. Okay, so employees, workers and contractors. You'll probably, most of you have heard about a case involving Uber, the taxi company, whereby its drivers actually challenged whether or not they had employee status. And the Supreme Court held recently that drivers engaged by Uber were not self-employed contractors, which is what Uber was stating, but that they fell squarely within the legal definition of worker under the Employment Rights Act. And it's probably just worth talking for a minute about sort of the difference between each of these three categories. So to be an employee, you should have a contract of service or apprenticeship, and the work that you do is actually under the control of an employer, and you're really very much a part of the employer's undertaking. You're not in business on your own account, and there should be some kind of mutuality of obligation between you and your employer. A worker is similar but different in that they should also have some kind of contract, ideally written, but it could be verbal or implied. And the contract is for them to perform services for another party. And that party is not their own client in their own business. It belongs to, the client belongs to the party that they're doing the work for. And then you get the self-employed who are very much in business on their own account, whose clients are working directly for them. And essentially, in terms of employment rights, certain employment rights only apply to employees. And that's things like the right not to be unfairly dismissed and the right to a redundancy payment, for example, if you've got over 2 years service. But workers, such as the Uber drivers, are also entitled to some rights. And that includes the right to paid holidays and the national minimum wage, which is why they're obviously delighted with the result from the Supreme Court. Self-employed contractors are sadly not entitled to any employment rights. So I think the importance of really clarifying that and what the relationship is between the parties is really key. Okay, moving on to contracts. As I said, I know Nicola did talk quite a bit about this in terms of what should really be included. So just really to add that if you are employing somebody, you should issue written particulars from day one. And there's a whole list of things that need to be included, and that covers everything from the start date through to the rate of pay, the holiday and sick pay, pension entitlement, the notice period, and also details of disciplinary and grievance procedures and what would happen in the event of those needing to be used. Similarly, but different, a contract for services is what you should be providing to a contractor. Again, that should detail the parties and very much the services that the contractor is due to provide. And then it needs to clarify things like who should be providing the equipment, what the notice period should be to terminate the contract, whether the contractor can actually substitute themselves with somebody else, very much a difference between a contractor and an employee who wouldn't be able to substitute themselves. Things like the payment terms and also the tax. Another key difference is that a contractor would be responsible for paying their own tax. And this does lead on to IR35, which we've covered briefly. Essentially, it is changing, the law on this is changing from this coming April, but only for large and medium-sized employers. So those who have perhaps over 50 employees or a turnover of over £10 million. And the onus essentially is changing, is transferring from the contractor to the organisation that is paying them to actually determine whether are they essentially the same as a full-time employee, in which case the organisation should be deducting the tax before paying them, or are they truly in business on their own account and working for a number of different organisations, in which case, as long as there's a contract for services in place, they can continue to be a contractor. We would recommend a contract for services, even if your organisation does not currently qualify for IR35, because it will no doubt down the line, and it just makes it very clear whether the person is an employee or a contractor. Okay, moving on to the right to work in the UK. Anybody who employs somebody in the UK has a legal duty to prevent illegal working, and there is actually a £20,000 fine per worker who is employed illegally. So it's obviously really key that as an employer, you at the very beginning make sure that you've checked the documentation, whether that's a British passport or whether it's another passport which has a visa enabling the employee to work in the UK. And it's important that you sort of keep that in a clear system, that if you ever were audited by the Home Office, you could actually show that you did make that check. Now, following Brexit, obviously there may be a number of people who were EU citizens, not necessarily British citizens, who were working for employers in this country. And the government has introduced an EU settlement scheme, which will enable those people to actually establish, how long have they been in the country, and they can apply through this scheme, and they'll be given either settled status, which means they've been in the UK for 5 years already, and they're able to continue to live here permanently, or pre-settled status, which will give them that same right once they have been here for 5 years. So the deadline for that is the 30th of June. In terms of taking on anybody else going forward who doesn't currently have the right to work in the UK, all foreign nationals will now actually need to go through the skilled worker route, and an organisation would need to have a license, a sponsor license, to sponsor somebody to come across who doesn't currently have the right to work here. So I would recommend you take immigration advice if you do plan to do that. So that's just touching on the right to work in the UK. Okay, focusing now for a bit on employee rights. There are a number of employee rights which employees have from day one. And one of those is the right not to be discriminated against. And that actually covers, under the equality laws, quite a broad range of protected characteristics. So we shouldn't be discriminating against anybody on the basis of their race, their sex, their age, their marital status, sexual orientation, etc. And that's from day one. Likewise, once you've put a contract of employment in place with somebody, if you were to breach that contract and perhaps dismiss them without the notice that's in the contract, or breach one of the other terms, they would have a right to claim breach of contract as soon as that were to happen. As far as unfair dismissal is concerned, however, you have to have 2 years service to be able to make a claim for unfair dismissal. And there are actually 5 fair lawful reasons for claiming unfair dismissal. So that would have to be, sorry, put it the other way around. For a dismissal to be fair, there are 5 lawful reasons. So one would be capability or performance. One would be conduct. Another one is redundancy. The fourth one is a statutory illegality, e.g. the person no longer has the right to work here. And the last one is some other substantial reason, which covers a whole range of things, including perhaps the person no longer has a driving license and they're employed to be a driver. So as long as an employer can show that they followed a fair process and that they had one of those legal reasons, it is fair to terminate someone's employment over 2 years, but it is quite onerous to be able to show that you followed that process. So I've really included two key cases, both of which went to tribunal, and one which was shown to be fair dismissal and the other one unfair. So the first one here is Kubilius versus Kent Foods. And this is quite a recent case where the employee refused to wear a face mask, which was a requirement of the client of Kent Foods.
Thank you.
That they were working for. And the employer went through a fair process of investigating this allegation and then eventually dismissing them. And the tribunal found that it was a fair dismissal because they had very clear policies to say what PPE should be covered when working at a client, and the employee had clearly not followed them. He also was unwilling to accept the fault that he'd done anything wrong. The other case, Compass versus Celebi, was actually a case of unfair dismissal. And the employer in this case was criticised for not being clear with the employee what the allegation was. And the ACAS code, which is a code that we should follow, even if we don't have our own policies, it's sort of the minimum standards for disciplinaries. And it states very clearly that an employee needs to be able to prepare an adequate defence, which involves knowing and understanding the allegation made against them and having time to prepare a response to it. And in this case, they didn't have that, so it was considered unfair. Okay, touching on social media and the workplace, which I know is something that lots of us are using both in our personal and our professional lives, I thought it'd be helpful to give two cases again of unfair dismissal. So the first case is Whittam versus Ventura. The employee was called Whittam, and they posted some comments on Facebook about their colleagues. They didn't mention any colleagues by name, and the post resulted in other people making comments about the post. But the individual had privacy settings, which meant that only her friends could actually see the post, and no other member of the public had access to this. She was very apologetic when the employer asked her about it, but she was still suspended and dismissed. And even when she appealed the decision, it was upheld. However, when it came to tribunal, the tribunal found that the dismissal was unfair because essentially, although the company did have a policy about the use of social media, in reality, the tribunal felt that the action was too harsh. The employee had been apologetic, had been remorseful, and actually she had privacy settings, which meant that really there hadn't been very much damage. She hadn't actually named the colleagues, and the damage had been very much limited. And whereas they may have decided if they wanted to, they could have perhaps given a warning, but it was felt that dismissal was too harsh. In contrast, the other case I've written here, Priest versus Wetherspoons, excuse me, the comments put on Facebook were abusive comments about the customers. And in this case, it was felt that Wetherspoon's action was very much within the band of reasonable responses of an employer, which is quite a key term that an employment tribunal would look at in deciding to dismiss the employee Priest. And I think that's what we really need to look at. Like, I would definitely stress that if you have employees, you should have a social media policy, because it does make it clear to employees sort of what is acceptable and what is not. And generally, I would say, it's best to avoid making comments about your employer, but what you do on a private basis, to some extent, is up to you. And obviously, employees need to be aware of the policy and make that choice. But there is a crossover, and I think it is, once something's on social media, it's quite easy for it to be spread much wider. So certainly the starting point should be to have a policy. Okay, touching on now the furlough scheme, as you will know, it has been in place for a whole year now, and last week in the budget, the government extended it until the 30th of September. For those who don't know, the government is currently paying 80% of the hours that employees don't work, up to a cap of £2,500 per employee. And the employer does still have to pay the tax and national insurance on that money, but obviously this is an incredible help to particularly companies who've been very much affected by the pandemic. So this is going to continue until the end of June. And then in July, the grant from the government is going to be reduced to 70%, with 10% topped up by the employer. And in August and September, that's going to be reduced to 60%, with 20% topped up by the employer. So the key issues that have been stated with regard to this extension is that any employees who've not previously been furloughed but are going to, for whatever reason, going forward, they must have been on the payroll on the 2nd of March. And one key point, which is the same for employees who've been furloughed up until now, is that you must have a written agreement with each employee that they have agreed to be furloughed, and unless the employee is topping up to 100%, that their salary has been reduced to 80%. And the reason I stress that is because HMRC have obviously had to investigate quite a lot of cases. There have been some cases of fraudulent use of the job retention scheme. And so they've asked employers to keep those agreements for 5 years. And just in case you or your employer was audited, it's definitely something you should have in place. Okay, moving on to the final topic of redundancies. Obviously, organisations do have to restructure from time to time, and sometimes this does result in redundancies. And as I mentioned before, anybody with over 2 years service has the right to claim unfair dismissal. However, an employer can go through a redundancy process as long as it follows a fair and genuine consultation. And we would recommend a minimum of 3 meetings with the employees who are affected. The first would be where you put the proposal to make redundancies to the employees. And it's important to use that word because it's not set in stone. And if it was set in stone, it wouldn't be a genuine consultation. Obviously, the employee has to kind of understand, digest the news, and then should be able to go away and reflect on it, and then come back for a second meeting at which they should be able to ask questions about the rationale for the redundancy, and perhaps put forward any alternative suggestions that they have as a way of avoiding redundancies if at all possible. That's not always possible, but the employer does need to actually take away and consider any suggestions that have been put in place, so that again, they're showing that they've looked at all alternatives and it's a genuine consultation. If you have a situation, say you have 5 managers who all do a similar role and could have transferable skills, and the organisation can only justify maybe 2 posts going forward, you need to have a fair, objective way of actually selecting people. You can ask for volunteers. You can either incentivise or just ask if someone doesn't want to go through a selection process, if they want to come forward for voluntary redundancy. But if they don't, you need to have fair and objective selection criteria through which you actually select people, and therefore if they did want to take you to tribunal, you could defend your decision. So we would tend to recommend a sort of skills matrix where you use objective criteria such as their previous performance and job knowledge, their qualifications, their flexibility, perhaps their absence, where you can rate the different employees on as fair a basis as possible, and then select them for redundancy. And obviously, if you have records like appraisal records, which are objective, then that's even more helpful. We would also recommend that all meetings there's notes taken of them and they're minuted, and that the relevant letters that you need, which we can help to provide you, are given to employees throughout, so that if you ever had to defend your decision, you've got a clear, fair process that you've followed. One other point to make is that those on maternity are protected, and their protection has recently been extended. They are now protected from the moment they tell their employer that they're pregnant until 6 months after they return to work. And in a redundancy situation, if there were more people than jobs, essentially, if they meet the criteria for a role, they would actually have preference in getting that job if they were on maternity leave. So that's really all I was going to cover today on on redundancy, except to add that I think we all probably know people who during the pandemic have been affected by redundancy. And whilst our clients are generally employers, I just wanted to offer out, if you do personally know anyone who is going through redundancy, who just wants to speak to somebody free of charge, just to say whether they're, being treated fairly, making sure that they're getting what they're owed, please feel free to put them in touch with us, really. So just to say, are there any questions?